That's good. The ceiling was nice, but I didn't think that's what we were going to watch the whole oral argument here.
I was hoping that.
Me too. Okay. All righty. Mr. Radchek, I believe you represent the appellant in this case. Is that correct?
I do, Your Honor.
And would you like to reserve any time for rebuttal?
Yes, sir. If I could reserve 5 minutes, that would be great. And I am trying to get this camera to focus a little bit better there. There we go.
Okay. You look like you're in focus. Time now, you may start.
Thank you, Your Honor. May it please the court. Although the trial court judge below, Judge Scott Stevens, ruled in favor of PODS, he did so solely because he said that there was no Florida court that had yet ruled on the legal issue that we're addressing now today. But he embraced the legal issue that we're dealing with and the arguments and theory supporting my client's claims. In fact, Judge Stevens—
The theory is breach of contract, right?
The theory is twofold. One, that there is a breach of contract, and two, that there is a breach of the covenant of good faith and fair dealing.
Well, but that doesn't stand alone, right?
No, ma'am, it does not. We recognize—
Okay,
that—
so let's get right to it. What is the contractual provision that you believe was breached?
Okay.
And how was it breached?
There are two provisions in the agreement that stand on this. The first is section 2.2 of the franchise agreement, and the second is section 2.4 of the franchise agreement. Section 2.2 confers upon the franchisees the exclusive right to operate their franchise business within their exclusive protected areas. As part of that right to operate the business is the exclusive right to use the trademarks in their restricted areas. Section 2.4 of the agreement specifically provides that PODS does not have the right to grant anyone else, including PODS, but any other person, the right to use the marks within those protected areas. Under the law, as Judge Stevens recognized, should probably be applied here, but needs this court to determine it. The case of original appellation in the first instance, and then the case of Chroma in the second instance.
Let me just stop you. Can you describe for me what the breach of contract was, please?
Sure.
You specified the provisions.
Yes, specifically section 2.2 says that in their contract, as I said, the franchisees have the right, the exclusive right, to operate their franchise business within their protected areas. Section 2.2 specifically also says that with that right comes the exclusive right to use the marks within their territories. Section 2.4 of the agreement specifically says and prohibits PODS from doing anything that grants the right to any other person to operate.
So how did PODS breach that contract?
What PODS did under the original appellation and Chroma cases is it granted to U-Haul a license to use the marks within those territories.
I thought it sued U-Haul and it got a permanent injunction that enjoined U-Haul from using the marks.
It did, and that's prospective harm. But what PODS also did was it not only sued for the injunction, but it sued and then importantly settled with PODS for $41 million based upon damages that not only PODS but the franchisees sustained. And under those—
doesn't that go to the like Chroma and the good faith and fair dealing, the implied obligation?
It goes to both, Your Honor, because under both cases, and then looking back to the McClintock case, what PODS did when it settled with U-Haul and or went to court and took money from U-Haul was it effectively conveyed a license to U-Haul for the use of—
I don't understand that. I do not understand that. You're going to have to try to explain that to me. I'm sorry.
Okay, well, the case of Chroma, again, original appellation relying upon McClintock and then Chroma as well, says if you pods effectively want to go out and take money from an infringer, you are condoning, you're allowing, if you will, that person to use the marks, and the use of those marks constitutes a breach of the agreement. It is both, I think, a legal recognition of the fact that you are conveying the court in original appellation called it an involuntary license, relying upon McClintock, but effectively you're going out and you're saying, here, you pay us for the use of this mark.
No, but they didn't allow them to use it. They got an injunction to prohibit them from using it.
But that's going forward, Your Honor. That's not addressing.
Well, they had to sue in order to get the injunction. They never at any time that I noticed in this record said, oh, U-Haul, it's okay. They sued them.
They did sue them and then, of course, settled with them, but they didn't just sue them to stop the use. They
got damages as well, and for corrective advertising, and then they got disgorgement of profits.
Correct, Your Honor. And what they really did was they said, okay, we'll take care of the injunction is nice and it's important and it's great. We'll get to that on the issue of whether or not that satisfied the covenant of good faith and fair dealing going forward. But what it did was it said, okay, you infringed, you used our marks. Now pay us for it.
So you're saying they effectively granted a temporary license, is what you're saying?
Effectively a retroactive license. That's exactly what the court says. It says.
Well, wait. Let me make sure I understand the elements of the award. Part of it was for corrective advertising.
Yes, ma'am.
Correct. Okay. And then the rest was disgorgement of profits, which was the wrongfully earned profits by U-Haul. And disgorgement was the measure of damages because PODS, it didn't really have the ability to prove what it lost as a measure of damages. So instead, the award was measured by the wrongful gain of U-Haul. Now, were there any other elements of damage?
No, Your Honor, that's a recognized, effectively a substitute measure of damage.
Right, when you can't prove.
Right, when
what you lost.
It's hard to prove a sale that didn't occur.
Right. No, I understand what disgorgement is.
Right, but all of the evidence that was presented by PODS at the trial was predicated upon the fact that PODS and the franchisees lost sales to U-Haul, and in fact, that was specifically in their complaint. They specifically pledged.
But they weren't awarded damages for that, were they?
They were. That's exactly what the damages were.
I thought you said the damages were disgorgement.
Yes, the damages that were awarded were disgorgement, but it was predicated upon the fact that U-Haul made sales at the expense of PODS and the franchisees. They would not have made those sales or those profits had they not infringed and harmed PODS and the franchisees by taking their sales. In fact, in the complaint, they alleged that U-Haul engaged in a systematic plan to steal business sales from PODS and the franchisees. And then PODS at the trial put on evidence, testimony of experts, witnesses, executives of PODS that all went to the fact, and the franchisees themselves, that all went to the fact that they lost sales, they lost business to U-Haul, and that hence the disgorgement was appropriate to compensate PODS and the franchisees for their damages.
But that was not straight up loss of sales. That was evidence presented to show dilution of the mark, wasn't it?
No, Your Honor. And in fact, that's sort of this great myth that PODS keeps putting on now in this case, that they never introduced at the underlying trial. And in fact, in this case, and we cite to it in our briefing, the CFO of PODS specifically testified that there was no diminution in the value of the marks or the brands, that they never focused on that in the PODS case below. They never valued it. They never analyzed any impact on the PODS brand or marks, and that they've never adjusted the valuation of the brands or the marks as a result of PODS activity. So while we've heard a lot about that in this case, it didn't exist in the underlying trial. And that's one of the great myths that they are putting forth to this court in an attempt to avoid what they really did in the trial court below. Now, you've also asked Judge Kelly about whether or not part of the damages that were awarded were for the corrective advertising. Let's bear in mind that the advertising has been paid for by the franchisees, right? So in order to compensate the franchisees for their injury suffered as a result of the misconduct, you have to compensate them by allocating to them part of that corrective advertisement. Had PODS in fact used the money that it took from U-Haul, supposedly for corrective advertisement, which even Judge Stevens recognized they never did, and he alluded to it as a windfall, then they would have properly shared it, but they never used it to either discount, reduce, offset any of the charges that PODS franchisees paid for advertising or historically paid. In fact, the evidence in the record shows that after they got the $41.4 million, they increased the amount that the franchisees had to pay for advertising and didn't use any of the money that PODS recovered from U-Haul for advertising purposes. There's undisputed evidence in the record for all of this. And so what happened is PODS took $41.4 million and put it into its general operating account, even though it recognizes specifically that PODS franchisees were hurt by U-Haul's conduct. And PODS, as you said before, effectively granted, whether you call it a temporary or perhaps retroactive license for the use of the marks, it breached the contract specifically under the original appellation, the McClintock before that, and then the Chroma case in the Florida Middle District, which applied Florida law.
But go on, Judge Kelly.
No, you go.
None of those cases involved a retroactive or a temporary license.
They all did. That's exactly what original appellation talked about.
No, original appellation said, you pay us off and we promise we're not going to sue you and we're not going to let our franchisees sue you.
Yeah, they said that to settle the damages historically, right? And there's something that PODS has said in their briefing, that they said that they sold out the franchisees and didn't obtain an injunction. There's nothing in the record that discusses an injunction one way or another. It said, we won't sue you, but it also presumably said, because you're not going to infringe anymore. There's an agreement not to infringe as part of this settlement agreement. Now, if the defendant there, if TOPS went ahead and infringed again, I'm sure that they would have sued for it. So it was a settlement agreement to prevent future infringement, but it was a payment all for historical retroactive damages that even the court recognized that if the licensee could prove that it suffered damages as a result of it, it would be entitled to share. Now, If I might, let me go on to the issue of the covenant of good faith and fair dealing, unless the court has any further questions on the breach of contract.
FYI, you are at 14.
Okay, I'll do it very quickly and I'll reserve part of it. The cases all talk about the covenant of good faith and fair dealing, and they talk about it equitably. Judge Stevens, I'm sorry, unfortunately went a little bit astray when he then ruled that the injunction was sufficient to take care of the covenant of good faith and fair dealing. Again, that only goes on a prospective basis, not retroactively. But he also cited the cases of Seppi and Chalfanti, which talk about a situation where the covenant applies to all contracts, but those cases, and also the cases that PODS relies upon, talk about whether when the licensor has the right, or I'm sorry, the power, but not the obligation to act. And we don't have that here. We don't have a situation as to whether or not the injunction was good enough because PODS only exercised the power to the extent that it wanted to, i.e. the injunction. That would be a hypothetical that doesn't exist here. Here we have very specifically PODS seeking monetary damages in the first instance. If PODS didn't want to seek monetary damages, i.e. convey the license to U-Haul, it didn't have to. Or hypothetically, it may not have had to. We can address that when and if that issue ever comes up. But here they exercise the power that they had to get money from U-Haul. So that takes it out of the context of Seppi, Chalfanti, the Murella case that PODS cites, or the Jeffries leveraged credit products case that they cite, in which case they talk about a situation where you don't have to do more than you're obligated to do. But here we have PODS who did do more than it says it was obligated to do. And as a result of having done that, it breached its covenant of good faith when it refused to share the settlement proceeds based upon the license that it conferred. I recognize.
While we're on this point, may I ask a question? I'd like you to clarify something for me.
Please.
Seppi in those cases deal with an implied covenant of good faith and fair dealing.
Yes, sir.
The attachment to this pleadings, and I was looking at it, paragraph 20.1 has a written express provision for good faith. Are we going on an implied theory, or is this the correct contract that was being used in this case, and was it changed by the addendum?
No, nothing was changed by the addendum, Your Honor. And so
20.1 has an express covenant it says the parties expressly agree that this agreement contains an express covenant of goodwill and fair dealing. So are we dealing with an express or an implied or both covenant?
Both covenants, Your Honor.
So express and implied?
Yes, sir.
Okay.
Yes.
Thank you. I just wanted to be sure that I hadn't misread that contract and that it was pertinent to our legal analysis.
It is, Your Honor, and thank you very much. I'll reserve the rest of my time unless there are any other questions.
Thank you.
Good morning, Your Honors. May it please the court, Jeffrey Buckholz.
One second. I'm unfortunately a timekeeper and I'm trying to multitask. No, it's not your fault. Write down my notes so I don't lose the thought and then clear the button so you don't start off with his time counting against you. We are good, counsel. Please go ahead. Thank you.
Thank you, Your Honors. Good morning. May it please the court, Jeffrey Buckholz for PODS. I'd like to start with the question that Judge Kelly started with. This is a breach of contract case, and yes, there's also a claim for breach of the implied covenant, but as Judge Kelly pointed out, that claim doesn't stand alone, and therefore, really, this is just a breach of contract case. So the theory, there has to be a theory for some provision of the contract that we breached and how we breached it. And I think what we've just heard is that theory is that PODS granted U-Haul a license by suing U-Haul, getting an injunction against U-Haul and collecting damages for U-Haul from infringement. And that just doesn't make any sense. It doesn't make any sense to say, either in reality or in law, that somehow conveys a license to U-Haul in exchange for money. And if Your Honors, I'm sure, have seen in the franchisees' briefs, there are multiple places where they resort to phrasing like pods allowed U-Haul to infringe in exchange for money. And Your Honors, that's just not what happened. Pods did everything it could to stop U-Haul from infringing and got an injunction. And unlike an original appellation, where the licensor initially won a motion for an injunction and then gave up the injunction, didn't pursue that further, and instead got money, when we settled with U-Haul, we preserved the permanent injunction in perpetuity, in addition to getting the $41 million in settlement. So we did protect the interests of the franchisees by getting that injunction and preserving that injunction in the settlement, beyond anything that the duty of good faith could have required us to do, given the language of this contract. And I want to come back to the language of this contract, because it's a contract case, and the language of this contract is what governs, not the language of some contracted issue in another case. We heard a lot about McClintock just now. And McClintock is a great example of a contract that's very different from this contract. In McClintock, the contract said that the licensee had the right to 50% of the proceeds of the sale or other disposition of the rights at issue, of the work at issue, excuse me. And so of course, where there was another disposition through litigation of the rights at issue, the contract said the licensee got 50% of those proceeds. Well, here, far from anything like that, the contract says in section 5.1, this is page 1829 and 1893 of the record. Actually, let me just say parenthetically there, it's a little bit confusing because the original contract is first at 1829, and then there's an addendum that changes some terms. It doesn't change any of the terms relevant here. None of the contractual language that I'm going to quote to Your Honors was changed in the addendum. So whether the court looks at the 1829 or the 1893 site, it's the same language. The language is, this is 5.1. It says, you, the franchisee, acknowledge that we pods own the marks. Your right to use the marks is derived solely from this agreement and is limited to conducting the franchise business pursuant to this agreement. This agreement does not confer on you any goodwill or other interest in the marks, and your use of the marks and any goodwill established thereby inures to our exclusive benefit. So here the contract says in black and white, the agreement does not confer on you, on the franchisee, any goodwill or other interest in the marks. Well, the franchisee's complaint in their breach of contract claim says that they have an equitable interest in the marks, and they rely on a case like McClintock, where the court said that the licensee was a part owner of the work because of the way the contract was phrased. Well, there's just no way to say that here, given the language of this contract between these parties. They have no interest in the marks. So how do they get from no interest in the marks and all of the other contractual language to the same effect to this idea that they somehow have a right to share in the proceeds of an infringement action?
Let me ask you, because I was wondering this reading original appellation, if the appellants are actually in the same position as Diamond was in that case. And it seems to me that the appellants are one step removed in that, using original appellation as the example, they are more like, say, a stationery store that was licensed to sell Cabbage Patch Kids merchandise, and in the context of making those sales could advertise, hey, we've got Cabbage Patch Kid merchandise. And would that be more akin to the role that the appellants are playing vis-a-vis pods, as opposed to Diamond's role, which was manufacturing the stickers and using the mark itself on the, using the trademarked imagery on the stickers? I mean, is it your position that they're not even in the same position, and so the case is not applicable for that reason?
Your Honor, I think the original appellation is not applicable for multiple reasons, some that you alluded to and other ones that I'll try to explain. So this is a franchise agreement. This isn't just an exclusive licensing contract like McClintock, or like even if original appellation could be thought of that way, where a licensee has the exclusive right over a work or what to do in a certain channel with a work. This is the exclusive right that these franchisees have is to operate the franchise business. And yes, they have the right to use the marks in connection with doing so, but it's not as if we gave them the exclusive right over our marks. I mean, the contract is in 3 different places says the contrary, that we have the right to retain all ownership of the marks and all discretion with respect to the marks, and all goodwill inures to our benefit. And in 2.5 national accounts, we and other franchisees get to use the marks even in any other franchisee's exclusive territory. So in short, this is the franchise agreement context. It's quite different from the exclusive licensing context at issue in some of the cases they rely on. And I think it's important. I mean, so in other words, it's not an accident that this contract is worded differently from some of the contracts at issue in for example, McClintock, where it's a more traditional exclusive license arrangement. But the other important differences with original appellation are, number one, original appellation, as I said before, originally the licensor moved for and was granted a preliminary injunction to stop the infringement, and then decided they didn't want an injunction. After all, they wanted money in exchange for allowing the infringement. And I just heard Mr. Ratchik say that somehow the settlement agreement there that involved the payment of money to the licensor also prevented further infringement. And I'm sorry, Your Honors, the case doesn't say that. There's just no reference whatsoever in either of the original appellation opinions to that notion. And there's just no basis for that. So here, rather than foregoing an injunction that would have protected the franchisees in exchange for more money from U-Haul, we preserved in the settlement the permanent injunction against U-Haul and thereby protected the franchisees. The other important difference with original appellation is the 11th Circuit in original appellation repeatedly relied on the notion that the licensor had a fiduciary relationship requiring it to protect the licensee. Well, here in section 20.1 of the agreement, it says, neither this agreement nor the dealings of the parties pursuant to this agreement shall create any fiduciary relationship or any other relationship of trust or confidence between the parties. And the franchisees tried anyway to bring a claim for breach of fiduciary duty. Trial court dismissed it appropriately, and the franchisees haven't tried to appeal that dismissal. But really what they're trying to do in relying on original appellation is smuggle in this notion of a fiduciary duty anyway through the breach of contract claim, contrary to the explicit terms of this contract. So original appellation, properly understood, supports us, does not support the franchisees. And the same is true of Chroma, the other case that they rely heavily on. And McClintock I've already addressed, where McClintock actually exemplifies what a contract would look like that does give the licensee a right to share in the proceeds. And in Chroma, one important difference in Chroma is that the parties in Chroma appear to have agreed, this is from the 11th Circuit's decision, that there was an obligation by the licensor to indemnify the licensee for damages suffered by the licensee from the infringement. Well, there's no provision like that in this contract. And so, of course, if you have a contract that says that the franchisee, that the licensor owes money to the licensee if certain things happen, well, then if those things happen, the licensor owes the money. That's what the 11th Circuit said. That, there may have been a breach of contract claim there because of the terms of that contract that provided for an indemnification obligation. There's no claim like that here. There's no provision in this contract that would support it. And really, the language that the franchisees seize on from Chroma is from a decision denying a motion to dismiss. And it's not just that it's a preliminary. The trial court here was correct in saying can't rely too heavily on that at face value because it's just a preliminary decision denying a motion to dismiss, but it's more than that. It's the trial court in Chroma granting a motion to dismiss a promissory estoppel claim, which is what the licensee had brought, in the process saying you can't bring a promissory estoppel claim because there's a contract here, and where there's an actual contract, you can't rely on this kind of extra contract promissory estoppel notion. Well, then ironically, the trial court in Chroma goes on to say, maybe you can bring a contract claim relying on this notion of good faith and fair dealing. Well, as your honors know, Florida law is crystal clear that you can't do that through the good faith and fair dealing duty either, just like you can't through promissory estoppel. If there's a contract, the terms of the contract govern. A claim for breach of the duty of good faith and fair dealing isn't a standalone claim. It doesn't add anything to the contract. There has to be a provision of the contract that's breached, an actual provision of the contract. Here, there is none. So I just want to mention a couple of other provisions of the contract that reinforce the points that I've made. In addition to 5.1, which says the franchisees have no ownership interest in the marks and we retain all goodwill and all interest, 2.7 reinforces that. It's entitled Our Reservation of Rights. And it says, except as otherwise expressly provided in this agreement, we pods retain all of our rights and discretion with respect to the marks. So the question under 2.7 would be, is there something else in this agreement that expressly departs from that expressly gives the franchisees a right to share in the proceeds of infringement? And there isn't. There just isn't. And that's why they have to concoct this notion, this contrived idea that somehow we granted U-Haul a license by suing U-Haul and preventing U-Haul from infringing. That just doesn't make any sense. It's contrary to reality. I want to briefly address points that were made about what happened in the U-Haul case and what the damages reflected. And Your Honors, the best evidence of what happened in the U-Haul case and what we recovered in the U-Haul verdict is the evidence from the U-Haul case itself, right? There's a full record that's in the record here from the U-Haul case. And what the franchisees are trying to rely on is depositions that they took years later, years after the U-Haul litigation was over, of some people who had testified or been involved in the U-Haul litigation, where Mr. Ratchick tried to get them to agree to some imprecise or tendentious characterizations of what happened. And sometimes they let those words get put in their mouths. But Your Honors, none of that matters. What matters is what actually happened in the U-Haul case. And if Your Honors look at the U-Haul case record itself, Your Honors will see that we did not present, a claim to the jury for lost profits damages. Yes, we said that we were harmed, including through losing sales by U-Haul's infringement. Yes, franchisees who testified said that they were harmed as well. There were a few anecdotes presented to the jury where customers would call and seem confused about whether U-Haul and PODS were the same. And so, yes, there were anecdotes like that presented, and the U-Haul jury, hopefully believed that PODS and the franchisees were injured by U-Haul's infringement. But that's very different from actually presenting a damages theory to the jury, where you're trying to prove and quantify your lost sales and your lost profits and recover damages measured by that. We didn't do that. So at page 36, 62, and 63 of this record, we have Walter Braddock, who is our damages expert in the U-Haul case, who tells the U-Haul jury, he admits on cross-examination, quote, "I did not quantify any lost sales or lost profits due to lost sales. I haven't quantified any lost profits or any lost sales in my analysis." That's crystal clear. Our other expert in the U-Haul case, Professor Russell Weiner, similarly at 1614 of the record, on cross-examination, again, admits to the jury in the U-Haul case. The question is, you don't know how much business, if any, PODS has lost by virtue of U-Haul's use of the term PODS, correct? And his answer is, what we've heard this week is we know they lost some business, but I don't know how much. That's correct. And that reference to what we've heard this week is the anecdotes I mentioned earlier, where people talked about certain instances of customers calling or prospective customers calling and seeming confused. And then maybe the best evidence of all, Your Honors, of what happened and didn't happen in the U-Haul case is the U-Haul court's order denying the post-trial motion. So if anyone knows whether we presented a lost profits case and recovered lost profits from the jury, it's the judge who presided over that case and that jury trial and who acted on the post-trial motions. That's in this record too. It starts at 1977, and at 1998 and 99 of that order, the judge addresses U-Haul's post-trial motion, arguing that we didn't prove harm as was required for us to collect damages. And the judge says, PODS was required to present evidence that PODS mark lost value to recover damages for corrective advertising. That is exactly what PODS presented to the jury. Evidence that U-Haul's use of the marks damaged the PODS brand. And so when Mr. Ratchick told Your Honors a few minutes ago that it's a myth, that's his word, a myth, that we presented evidence in the U-Haul case that our brand was damaged by U-Haul's infringement, Your Honors, that's just directly in the teeth of what the U-Haul court itself said happened in the U-Haul case. And so who are you going to believe? The U-Haul judge about what happened in the U-Haul case, or some argument made by lawyers that outside of the record in this case about what happened in the U-Haul case? I also want to just close by saying, if Your Honors have no further questions, that the argument about what happened in the U-Haul case and what the damages there reflect or don't reflect is a little bit beside the point, because again, this is a breach of contract case. And so unless the court is going to buy this notion that we somehow granted U-Haul a license by suing U-Haul and getting an injunction against them to prevent infringement, it doesn't really matter what the damages in the U-Haul case reflected. There's still no provision of this agreement that gives the franchisees a right to the marks or in proceeds of infringement of the marks, because that's just not what this contract says. So if Your Honors have no further questions, I'll cede the balance of my time. I know you have other cases this morning, and I'm happy to give some of my time back. Thank you, Your Honors. We'd ask the court to affirm.
Thank you, counsel. Let me clear the calculator here. Before you ask me, I will say you have 3 minutes remaining for rebuttal. I anticipated the question, the answer doesn't invade your time.
Thank you, Your Honor. Let me address just a few things. First, to Mr. Buchholz's comments about who you're going to believe, the witnesses now or the witnesses then. Let's be very clear that in the testimonies given in this case, in almost every case, in almost every instance, we ask the witnesses not independent questions, but to affirm their testimony from the U-Haul case. And that's how the evidence was presented in this situation. And then Mr. Buchholz says, who do you want to believe? Does this court want to believe the 11th Circuit in the original Appalachian case and the Middle District of Florida in the Chroma case as to what constitutes the conveyance of a license of the marks? And I would submit to you that you should adhere to those rules because they are on all fours here. Now, again, focusing on the original Appalachian, we're not dealing with a situation where, and we're not contesting who owns the marks, who retained the interest to the goodwill in the marks. That's the same facts as existed in the original Appalachian. And they made it very clear that it had nothing to do with ownership of the marks or the goodwill. What they found, however, was there was both this actual as well as implied covenant in there that you shall do nothing to harm the value of the marks, and that as the licensor, and there's no doubt that they're a licensor of the marks, even Judge Stevens recognized that, and the cases in Florida recognize that as well, is that you shall do nothing that harms the interests of the licensees in the marks. But that's what PODS did here, both expressly by granting that retroactive license, as we've talked about, and then to keep all the money from them that was given to them. You know, this is
Mr. Ratchick,
yes.
what in your view, the only way PODS could have escaped this sort of broad notion that if the franchisor gets money, the franchisees get their share of it too. The only thing that PODS could have done was not seek any monetary damages. All they could have done was sue for injunctive relief.
No, they could have, and again, we're talking about hypotheticals as to what might or might not be, but they didn't have to present evidence of the damages suffered by the franchisees. If they had collected damages unrelated to the rights and obligations of the franchisees, then we wouldn't be having this conversation.
So that was their breach. That was how they breached the covenant of good faith and fair dealing. That was how they harmed the interests of the licensees or the franchisees.
By doing both things, by giving away rights that directly impacted on the franchisees, and then two, by not sharing the damages that they sought and collected from U-Haul for the benefit of the franchisees. I mean, imagine this, if you go and sue somebody on my behalf for the injury to me, and then you keep that money, there's something wholly inequitable about that, especially when you promise me that you won't do that. You have an agreement with me that you will, one, protect my interests, and two, not give away my interests to somebody else pretending to do it on my behalf, but then keeping all of my money. And that's exactly what they did here. And to address the question that you asked earlier, Judge Rothstein-Jakob, about—
This will be, I think, safe to say your final response, since we're way past 3. I want you to answer the question, if you would.
You asked the question whether or not we are more like a stationery store, and I'm not exactly sure that I followed that question. But no, we are a direct licensee, granted a license to use the marks by PODS specifically to operate our business. We not only have the right, but the obligation to use those marks in the conduct of our business. And if somebody like U-Haul comes in and uses those marks to our detriment, and we can prove that it was to our detriment, which the franchisees have done, then that constitutes more the relationship that I'm talking about than the idea of a stationary store that just has to sort of mention it. We are direct licensees. Having answered that question, Your Honors, we ask that the court either reverse outright or remand with instructions to enter summary judgment in favor of PODS and award the damages, which I haven't had a chance to talk to, but which are in the brief. It's approximately $5.6 million in favor of the franchisees.
Thank you. Thank you both. We wish you well and good health as well, and will allow you to transfer over into whatever cyberspace room you're going in. And if I had a Mr. Scott, I would ask him to beam you over, but I don't. So our wonderful staff will take care of you.
You've got to
modern
stand in
times.
line for that one. So
Pardon me?
you have to stand in line for that one. Thank you, sir.
Absolutely. Thank you all.